the taxes reduced, the liability on the taxes reduced somewhat with a trust versus a will?
Well, a revocable living trust has no tax consequence because the person, the grantor, has not given up control. They still have control. We use many other types of trusts when we're talking about trying to save on estate taxes, life insurance trusts, things of that nature. But that is often the problem with the best estate plan. Won't work if the person creating the plan doesn't want to give up control. And very often that's what you find. An older person, perhaps, who may have lived through the Depression, has seen some lean times. Then they want to have control of their money. You could talk about life estates and grantor trusts and all these types of things, which will avoid depleting the estate if the person needs to go into a nursing home, which passes on money to the next generation, which avoids possibly estate taxes. But that person's got to give up control, and that's very often what you find is an impediment to implementing some estate plans.
So disclosure is a key word then. If the client isn't willing to disclose
Yes.
everything, and then if they pass away, then there's some issues to contend with.
Disclosure. Well, I heard once, there was a nice phrase I heard from an attorney. He called it GIGO. Garbage in, garbage out. So we're only as good as the information we're given. So you've always got to go give your attorney all the information they need to advise you properly. Garbage in, you're going to get garbage out.
So it's important if you're going to either go with a will or if you want to set up and do the estate planning.
Yes, obviously. A lot of times people come in and they've heard the catchphrases. My friend down the street, she's doing this trust or that trust, and I want to do that. And people are more and more familiar with certain terms, elder law planning and life estates and all of these things. So very often you find people, when they have to, they'll come in, I want to do this, and you'll talk to them and you'll say, well, what's your situation? What's your family dynamic? What are your assets, your income? And you have to tell them, well, you don't really need to do that, or you shouldn't do that. Perhaps you should do this. So, yeah, full disclosure is key with any attorney-client relationship.
Have you ever been involved in a will or trust that names a beneficiary, and then the beneficiary has passed away before?
Yes, and that if the beneficiary passes away before the testator, then it would still property would pass through the testator as well as if the beneficiary predeceased, and there would probably be language in that original testator as well dealing with that scenario. But you do have sometimes situations, I'm dealing with one right now, where the beneficiary passes away after the testator, but before the testator's estate is distributed. So now you're almost doing a double probate. And, that happens, and it can be more work, but it gets done. It's solved.
Not only for the audience but myself, can you describe or define what the testator is?
The testator, a person making the will, not necessarily the decedent. If you've made a will, you're still alive. You're the testator, and when you very often the term is used, interchangeably with the decedent post-death. The decedent, the testator, the person making the will.